Thank you all for tuning in for another episode of Stinging Back. This is M. I have A, and we are joined today by ICAC Unpacked's very own Norm.
Welcome, Norm.
Thanks, guys.
We're going to be going over the Michigan Supreme Court case, Michigan versus Jade. Now, this has caught all of our attention because it covers a lot of what entrapment is and a lot of the elements in these sting cases that we are against, but also reinforces what would you call it? How, Norm?
Yeah, what it does is it reinforces the elements of entrapment that we've talked about in all these cases. And similar to the Curry case out in the Ninth Circuit of September of this year, it asks the question, what is entrapment effectively? And they talk about two elements of it in both cases. That would be Curry and this one. It has to be inducement and a lack of predisposition, a willingness and a readiness to commit the crime. And we'll delve into that today as to what those elements mean in terms of cases just like this.
Okay, so we're going to start listening. This is the defense attorney who is defending Jade. And again, this is about defining what entrapment is, because it seems that entrapment has been applied differently to these online sting operations than what it is when they apply it to like drug sting operations. And you'll see that is a lot of what the judges are questioning about. Why is the standard different when applying entrapment to these online sex sting operations compared to the drug and even prostitution sting operations?
Oh, another thing we should touch base on. Okay, so this is the Supreme Court in Michigan. So Jade has already had his hearing and was convicted guilty in the lower courts. He went through an appeal court. The appeal found that the smaller court, the lower court, didn't do anything wrong. But because of all the, the way that maybe this is another episode. So it stepped all the way up to the Supreme Court through his appeals to make all of these points. And they touch base a little bit on this. The Pillett attorney for the defense talks about why he believes the lower courts didn't catch what the Supreme Court should.
If I could jump in, and this guy here, the bald gentleman, is Mr. Doman, as you mentioned, the defense attorney. And what, piggybacking on what you said, when we get to him here, he's going to do a great job because this case really tries to simplify things. Unlike Curry, which had a lot of moving parts, Mr. Curry had been convicted before and in another case, but just because you were guilty before doesn't mean you're necessarily guilty now. And that piece also comes into this as well, where, okay, what did the Jade in this case and Curry in the other case really do? And what were the elements of it? And let's get to him, because Doman here puts it very simply for people to understand. And I think it'll be very clear as we get through it.
Yes, and remember, in this case, this man, the defendant, the trial court found him guilty. The appeal upheld that guilt verdict, and now it's gone to the Michigan Supreme Court, and this is about defining entrapment. So let's see what this defense attorney has to say.
Your Honors, when we talk about entrapment, I think just as important as defining what entrapment is defining what entrapment is not. Entrapment is not a duress defense. It's not a voluntariness defense. It does not require the defense to show that the defendant's will was overborne. If we go back and read the foundational cases from this court, the United States Supreme Court, the crux of entrapment is really about stopping police from manufacturing crimes that otherwise would not have occurred. And the gist is really that we want police investigating real crimes, catching real criminals, rather than creating crimes for the sake of arresting and prosecuting people.
Okay, I'm going to pause right there because I want to point out, he points out that this is supposed to be about stopping real crime that was in the process of happening or that would have happened had police not intervened and stopped this crime. And so that's what the focus is going to be on. Em or Norm, do you want to comment on that before we move forward?
I think we can go on with it because he goes through and breaks it down and talks about how we don't need the usual way of looking at it. There's a subjective test which basically looks at what you, the defendant, did, and an objective defense which basically talks about what the cop did. And very often courts will split the difference, and they address that here, but in a very, very light way. They really focus on the key questions that we've talked about on ICAC Unpacked, and you guys have talked about here on Stinging Back. So why don't we just go forward, I guess?
So to me, as I read the case law, really the central question in any entrapment case is, were police manufacturing a crime that the defendant otherwise would not have committed? And I think all the different tests for entrapment, subjective, objective, and all these different maxims about mere opportunities and hypothetical law-abiding people and the 12 factors and all that, I think those things were originally designed to help us answer that central question about manufacturing crime. But at the same time, I think they can also serve to obscure the true meaning of entrapment and lead the lower courts astray, which I think is what happened in this case. And so that brings me to the second question that this court asked the parties to address, and that is whether the Court of Appeals erred by applying the standard that a mere opportunity to commit a crime is not entrapment without also considering readiness and willingness. And obviously, to me, the answer is yes.
Okay, so I want to stop there to point out the two questions that this court has to address. And the first one is, did police create a crime or manufacture a crime that would not have otherwise existed? And then the second question was, did the appellate court err in saying that this was not entrapment because that it was something to do with just offering an opportunity to commit the crime, and they're not considering the readiness and willingness. So you will see throughout this hearing that they talk about how entrapment should be about the readiness and willingness of the target, of the defendant, to commit this crime. Meaning, was he ready and willing before police intervened?
And they really delve into the idea of what does readiness mean and what does willingness mean, and why isn't it important? I guess I'm getting ahead of it, but why isn't it important when this occurs? We get hammered on your channel, on mine, all the time on, well, you knew, they told you the age and all this other hyperbolic stuff. Just this evening, I heard from somebody who said, if you go and meet, then obviously you are a dangerous predator. And, I take that very seriously.
Right. We'll talk about that because that's exactly what they're using to convict these innocent men. They're saying because you were told the age and because you went and met them, then you're guilty. And you'll see how what they talk about shows that entrapment has not been applied properly to these cases, the way it is applied to different types of sting operations, such as drug sting operations and prostitution sting operations.
And Mr. Doman also mentions that there's one area of what we indiscreetly, and none of us are attorneys here, obviously, and we're not giving legal advice here on this channel. We should mention that, nor on mine. Nevertheless, he gives one example of quote unquote trolling that's very, very important. And that is, he says, if police are just out there sitting, waiting for a child to show up and so that they can protect that child, he says, I don't have any problem with that. But that's not what's happening. And we've made that point over and over and over again. They're not doing as they claim, merely sitting there waiting for something to happen.
In People v. Jamieson, the case that this court cited in its order granting leave, the court said, quote, There is no entrapment if a policeman merely furnishes an opportunity for the commission of a crime by one ready and willing to commit the activity. And I don't think you can take ready and willing out of that maxim, because we have cases from this court and other jurisdictions where a mere opportunity.
Counsel, good morning.
Good morning, Your Honor.
I'd like to just keep things simple and go right to the point. This was a website that was designed for adults, was it not? It was an adult website.
Correct, Your Honor.
So ultimately, the defendant in this situation went to a website where he believed he'd be engaging with adults. That was his intent, was it not?
It was, Your Honor.
Okay, thank you.
This judge gets it.
This is one of those seminal questions that we keep going to, and that we've said now for years. It's like, if, predisposition, we've been told, is going to meet. Predisposition, we've been told, is talking to somebody who's underage, still, even after we learn the age, even though talking to somebody underage in a non-sexual way is not in any way illegal. So here this judge, as you said, gets it, because he says, well, I like to keep it simple. An element, I'm putting words in his mouth, but not by much, an element of intent, or he says intent, I'll say willingness, in the entrapment statute, willingness isn't really present. And in the federal statute, which the Curry case is about too, right? They talk about the four elements, I call them the four verbs. A person has to demonstrate that they persuaded a young person, induced a young person, coerced a young person, or enticed a young person to do something. And over in our cases, including mine surely, and others that we know of, none of that actually happened to a child in most cases.
That's right. But they focus on the willingness and readiness, and that's why that is how they've been able to convince juries and judges to find these men guilty. And so let's listen to the rest of this so that our audience can see how this defense attorney here and the judges unfold that to help people understand that it is entrapment regardless. Let's see what he has to say.
I don't think you can take ready and willing out of the mere opportunity maxim. And I think the late Justice Kavanaugh put it well in Jamieson when he wrote that a mere opportunity to commit a crime can be entrapment if the opportunity would not be normally presented, or if it requires the police to engage in some type of immoral acts. And I believe the prosecutor agrees with me, because they cite that quote in their brief as well. So if we recognize that a mere opportunity can be entrapment, I think that means that we always need to assess the ready and willing side of the equation. In Mr. Jade's case, obviously that didn't happen, in the Court of Appeals at least. The Court of Appeals decision is really replete with references to this idea that a mere opportunity to commit a crime is not entrapment, without also considering ready and willing. So I think it's clear that the Court of Appeals in this case erred in how it applied this court's entrapment jurisprudence.
Counsel, what do we do with the fact, on the ready and willing point, with the particular facts of this case, where perhaps his comment that she needed to be at least 16, and in fact he was charged with CSAA, which also requires it to be under 18, right? And so there's the comment of you have to be at least 16 is still, isn't it not indicative of a ready and willingness to commit a crime still, because this person willing to do it, she's 16, but that's still under 18, that's still a crime?
Right, Your Honor. So that's a great question, and I think two answers. Number one, under the objective test, we really need to be looking at what was the police conduct, and ready and willing under the objective test asks, was this police conduct designed to catch only those who are ready and willing to commit the crime? And that is, we look at that without reference to defendant by defendant analysis. The other thing is that, to me, ready and willing means what was the defendant's intent before he ever crossed paths with police. And so here, his intent was to solicit a consensual adult interaction. The question is not, did he become ready and willing to commit a different crime once presented with a different opportunity? We have to go back to what was his original intent and how that was manipulated by police.
I've said over and over on my channel, context matters. Notice how the judge asked a very good question and he answered pretty well. But they go on later, I think, to say, and I don't want to lose it because it's in the context of something else that they say, where Jade says, I'm looking for over 16. Okay. Well, that immediately causes them to grab onto that and say, ah, there you go, a magic age under 18. But that doesn't necessarily mean it could be less than 18. That's the
So Jade is thinking, so this was a profile of a 19-year-old. I didn't start this from the beginning, but they lured him with a profile of a 19-year-old. Now Jade is saying 16 because in Michigan the legal age is 16. However, if it is, and it's 16 if it's in person. If you solicit them in person, then it's totally legal. But if you solicit them online, then it's illegal if they are under the age of 18. So that is the point they are trying to make. And that's why Jade says you have to be at least 16. And the decoy said, they didn't say I'm 15. They said I'm almost 16. I'll be 16 in like a few days.
I see.
And they do that on purpose because they want him to be thinking 16, which is the legal age if you are soliciting sex in person. But if it's online, then it has to be, 18 or older. And so that's, you'll see that they'll bring that up later. But, or maybe I got that from another case. I'm sorry. I don't know if I'm mixing up my cases. But the point they're making here is, did the readiness and willingness, was it there before or after the police intervened? Was this man ready and willing to have sex with the minor before police intervened? Or did that readiness and willingness only happen after police introduced a minor into this adult sexual conversation or situation?
Yeah, I think they go deeper into that a little bit later on. Here they're discussing willingness and what that constitutes. And again, context matters. I remember when they came after me, the Commonwealth attorney, the assistant one, said, on the whole, if you look at everything Mr. Asian did, well, they only talked about the last 2 hours, basically. So they didn't look at the whole, and if they had looked at the whole and they had allowed us to enter that evidence in, they would have seen all the proactive elements that I did. And that's what I'm talking about here, is the context really does matter, and that's why they're delving down into it.
True. Em, do you have any input before I restart this?
Yeah, I have to reiterate what Norm said. In so many of these cases, there's only a fraction of the conversation that law enforcement focuses on. Norm's conversation lasted very long. Many other conversations that we deal with, or cases that we deal with, there's more missing from exculpatory evidence than there is subjected.
Right. So they just take snapshots that will help their case, and they will leave out the exculpatory evidence that shows entrapment or inducement.
And remember, we're the losers, so to speak, in the case, right? So, people like me they get to tell the story because they're the winners. And so they and they have the power in the prosecution. So they piece together this bizarre narrative, which happens to make them look like heroes if only you knew all the information. Here we have the judges who are peeling it back, asking the questions that we wish the trial courts would be asking. Because then you come up with very different outcomes.
So, I think when we talk about, well, wasn't he ready and willing to commit this crime, it starts to look a lot like predisposition, is my point, which we're not supposed to assess. So I think that line of thinking takes us somewhat dangerously close to the subjective test.
So, counsel, what would be a valid operation here? I know, I assume you would be okay if they were on some dark website where, right, it's known that everybody's underage. I think that's probably a easier line.
Right.
Let's assume they're still on Skip the Games. What would have been, is there anything they can do on that site that's legal with a decoy?
Yeah, I was thinking about that, Your Honor, and I think part of the problem is that Skip the Games is so explicitly designed for adults only. They have all these disclaimers about it's only for adults. If we catch wind of anything else going on, reach out to us. We don't need a subpoena or a search warrant or anything like that. Now, if at some point it becomes clear that those disclaimers are all lip service and everyone knows, and we have evidence that this is the go-to place if you're looking for an underage escort, it could be a different situation, but we don't have that in this case. And it was also interesting to me looking at the videos that CDAM presented, because in addition to these types of sting operations, Genesee County is also doing what they call rescue operations, where they're essentially trolling these websites looking for actual children being trafficked, and then they go out and rescue them. To me, there's zero problem with that. That's what they should be doing. So frankly, I think the resources should go toward those types of operations rather than these.
Okay, so I think what the judge is trying to get at with her question is that she must be aware, or they must be aware, that Skip the Games is an escort service website. So she's asking, is there anything legal that can be done on this website? Well, I'm assuming that if everything, the only things you can do on this website is all illegal, then the website would not be allowed to exist, right? So of course there has to be legal things you can use this website for. And an escort service, people assume it's just, to solicit prostitutes, but actually some of these people get paid just to maybe attend an event with the man or a woman, or maybe they get paid to cuddle or to come play some fetish for somebody, dress up like a bunny and hop around for me because, I have some fetish about, somebody dressed up like a bunny hopping around. So there's different things that people get paid to do and it's not illegal. And so I think that's what the judge is trying to get at, because you'll see later that it comes down to, was the man looking to engage in illegal conduct to begin with? Now, we know he was not seeking a minor to engage in sexual activity with a minor. That's pretty clear. But I think that's what this judge is trying to clarify on here. Are the legal activities that people go or use this website for?
I think this judge is trying to get at the parameters of where you draw the line. And I think they're great questions because, again, as I point out on my site too, and you guys have pointed on yours, where's the guardrails? Okay. We've seen, and there's been much discussion of the police operation manuals where they have set for themselves parameters and then promptly, crapped all over those parameters, okay? And it's going to get worse and worse as they have to come up with more and more stats. And by the way, with all this reduction in ICAC money and human trafficking money that Trump and company are siphoning away for some purpose, what is still in place is the law, the imperative that forces them to do this kind of work. So I don't know how they're going to do it without the money necessarily, which suggests to me they're going to get more and more desperate. So going through this and having parameters and trying to figure out where is the entrapment exactly going to happen? And where's the willingness? Where's the ready? Wait till they get to readiness because it's so close to willingness. Where is that line exactly? And that's what they're getting at. And it's really powerful stuff.
Yes, and I think that the main thing you'll see from this hearing is that they're trying to define everything. And going back to the question
Right.
this judge was asking, I think it has, you'll see later, it'll come up that other websites like Grindr and Tinder, those are not escort services.
Right.
Those people are seeking casual sexual encounters, which is totally legal. So there is no reason to believe that anybody there was seeking to engage in any illegal conduct. So why would police be targeting men on those, websites?
Yeah,
Uh,
and the answer is because it's easy. It's like shooting fish in a barrel, as they will argue. Well, children are sometimes on there. Well,
right.
again, as I pointed out, children are sometimes in hardware stores too. But if you want to find a bunch of children, don't go to a hardware store.
But whether children are on those websites or not doesn't matter because I mean the point is that police would have to show that they would have to show not only would they have to show that there are children on those websites, but they would have to show that they have reason to believe that these children are luring these adult males to engage them in sexual conversations like these decoys do, and to invite them to meet for a casual sexual hookup. And that's where the entrapment is. And I think that's what this judge is trying to get, at why would you target these men? What makes you think they are seeking any illegal conduct at all? Like, why would you lure them into this situation and then offer a minor to them?
Counselor, there's some indications in this particular case that there are standards or best practices around these police stings. There's a recording, there's training of a decoy, there's having the defendant be the first person to bring up. How do we look at that in the analysis? Is that part of the 12 factors? Is that something else? Like, how do we look at what should be happening as a matter of standard practice and when an investigation does or doesn't comply with that?
To me, I think that fits best under reprehensibility, and reprehensible being somewhat of a term of art in this context about what was the police's intent. Was it to catch people who they believed or had reason to believe were actually committing this crime, or were they creating these crimes for the sake of arresting people? And so when you have these kind of freewheeling operations that really have no operational constraints or do in name only that they're not following, and CDAM's brief had some really egregious instances of that. To me, that fits most neatly under reprehensibility, that they're not even following these constraints that they supposedly set out, that really their intent is merely to manufacture arrests at that point. So kind of what we touched on before about what does ready and willing mean. I think it's interesting that on page 30 of the prosecution's brief, they explicitly endorse this idea that, well, the defendant committed the crime, therefore he must have been ready and willing to commit it. If that's the test, then entrapment effectively ceases to exist because...
Yeah, that's a great point right there. And remember the case out in Washington State where they were trying to change the law and put some constraints on net nanny? I don't know if you both heard that case, but there was a law enforcement officer who said exactly as Mr. Doman describes here. He says, the same sort of mental gymnastics, that's not exactly the word I want either, the term of art, but he says, well, if we hadn't arrived just in the nick of time, who knows what could have happened, right? It's the same sort of thing here, Well, this is, if we had waited at all, or, if we had made any kind of concession, bad things would have happened. But we don't know that, because if they hadn't been there to begin with, none of this would have happened.
Well, and you'll see that they'll point out later that without the decoy bringing up age, this crime could not have existed. Like, if the decoy had never claimed to be underage, there is no way this crime could have ever existed.
And why was the decoy there to begin with is the issue for me. Where was the reason, the probable cause, the predisposition, the investigation they were doing?
Well, he makes a good point when he says if they're claiming that because the target or the defendant accepted You know, when they presented age, first, he doesn't break it down the way I'm breaking it down, but basically it's, this was a consensual adult sexual situation. And then they introduced an imaginary minor into that adult sexual situation. uh, if you are saying that because the defendant accepted right away that this is not entrapment, then entrapment ceases to exist, because that is the very definition of entrapment. That is why entrapment exists. You cannot offer or suggest to somebody, law enforcement cannot suggest to somebody for them to commit a crime. If a man was seeking a casual sexual encounter, that is legal conduct. If police say take a minor instead, that is them offering or suggesting to them, hey, commit a crime instead. That is entrapment. That is what this lawyer is saying.
What they do here, for example, is they'll say, well, you went to meet the person, therefore that's predisposition. That's maybe post-disposition. Predisposition means that, notice they were talking about the 12 factors. Well, in Curry, they have 5 factors. And I've read these factors in several other jurisdictions. Sometimes it's 7, sometimes it's 8. But you want to know what one of the factors is? That you had a prior charge, or your character and reputation indicate that you would have done this. And again, the police play games with this. We told you the name and you didn't back off. The age, excuse me, and you didn't immediately disconnect. Therefore, it impinges on your character. So,
Right.
all the time they're trying to nibble away at what predisposition is, what willingness is. I mean, in my case, I said we could both get in trouble, for example. But the context was I thought this person was being trafficked because they said I have to hide. They're looking for me. I don't want them to find me. I'm really scared. Right.
Right.
So I
And
was
if you're trying to help,
with the
if you're trying
person.
to help them,
Right.
yes, you would be in trouble with them, with the trafficker
So that to
wants.
them means predisposition. It couldn't be anything else. And again, what I was saying earlier about defining the narrative because they're in that position and not giving any benefit of the doubt or any possibility that it could be anything else. That's why they're able to do it. I mean, anything can mean anything if you put the right spin on it.
Right. And you'll see the point is that predisposition had to have been there before law enforcement intervened and introduced the crime. And we'll see more of that as it goes on.
We start from the premise that the defendant committed the charged crime, right? So again, I think it's crucial that we recognize the distinction of, did the defendant become ready and willing once the criminal opportunity was presented, or was he ready and willing before police ever entered the picture? And again, I think that's a distinction the lower courts missed in this case. So
Counselor, there's a lot of debate in the literature, sort of how objective or subjective this is. And so we have sort of mixed the two previously in prior cases. Is your position that ready and willingness is, an average person, or is it the defendant in this particular case? Which of those is your perspective on what this rule is?
Good question.
Yeah, that's a great question. I mean, under Gillette, it's a person similarly situated. So,
great answer.
Which I think some of the dissenting and concurring opinions in Gillette suggested starts to sound a lot like predisposition as well. In Gillette, the way that was applied was to the defendant's vulnerabilities, setting aside predisposition. So really, as far as I can tell, that's the best example of when we consider the particular circumstances of the defendant without predisposition. How that plays out in practice every day, I think, is a thorny question that I hope this court will bring clarity to.
So basically, the answer to that question is it applies to everybody in a similar situation. So when people or when prosecutors, law enforcement, or vigilantes are defending this and they're saying, oh, is this something any ordinary citizen would have, would have gone along with, would have accepted and said, oh, yes, I'm doing this. And that's what they're getting wrong. This needs to be applied to somebody in a similar situation. If you are online chatting with someone, is it normal to just automatically believe with certainty that this person is being truthful about their identity? Or is it more common to be confused or not really know and think this person may be who they are claiming to be, or they may not be? What they are telling me may or may not be true. Which one is more normal? To just automatically believe it because they told you online, or to think that it might be true, but it might also not be true, and to be confused about it? And that's what's not being presented in these cases.
So as I read the case law, ready and willing means would the defendant have committed the same crime without police involvement? And if the answer is yes, then obviously the police have not manufactured a crime because the defendant would have committed it anyways. And I think People v. Williams, the Court of Appeals decision that I cited in my brief, is a pretty good example of that, where police targeted a high drug trafficking area. They posted an undercover police officer on the corner as a drug dealer, and waited for people to approach the undercover officer, initiate conversation, and let the suspect ask for drugs. Didn't say, hey, do you want to buy drugs? Let the suspect do all the talking. And to me, that is kind of the quintessential example of a mere opportunity that someone ready and willing would seize. The person standing on the corner did not induce the suspects to seek out drugs. I think, objectively speaking, we can assume that if this person had not approached the undercover officer, they would have approached someone else. So to me, that's a great example of this maxim in practice.
Okay, so that was a good point. He pointed out, in drug sting operations, they are targeting individuals who were seeking drugs already. They were already seeking the illegal conduct. That is different from these online sting operations where these men were not seeking a minor. They were not seeking the illegal conduct that was later presented to them. So that's a big difference. And you'll see as this goes on how they point out, why is the entrapment defense being applied differently to these cases than it has been in the drug sting operations? If this had been a drug sting operation, it would have immediately be ruled as entrapment because police offered the drugs to the defendant. That wouldn't have even made it. The court would have just thrown out that case right away. They would have seen entrapment right away. But because these are, cases that are supposedly about sex with minors, they hijack people's emotion and they get lost in that. And that's what they're using to manipulate people and gaslight them. And, they put the focus on, this person, this monster was trying to meet a minor for sex. And they put all the focus on that so people can't think straight. And so it's easy to overlook entrapment when they do that. And that's how they're winning these cases. I like the way he's repeating some of the same things we have been saying for years, right? None of these men were looking for a minor.
Is it, I mean, are you asking us to draw a line, like had the defendant respond, when the decoy said, actually, I'm under 15, LOL, had he said, no problem, or great, even better, or you know, whatever,
Right.
Fine, clearly not entrapment, right? Like, that should, but when he said, nope, is that, you know, once that was said, is there some obligation on the police's part to then stop? I mean, in some of these cases, less so perhaps in this case, but in some of the others where it's repeated, you know, pursuing or trying to, even after the first no.
Like in your case,
a hard
Norm.
line at the first no, or the first, you know, indication of I'm not willing to commit that crime, even if, you know, in the next text, he's like, well, okay. You know, I mean, how do we draw that line? Or is it still looking at, you know, like what our existing case law does that, and the 12 factors help us sort of draw that line in a particular case?
To me, since we have the objective test in Michigan, the focus always has to be on the police. And the case law says that proper police conduct doesn't change from defendant to defendant. And so, frankly, I think even in the case where you have someone who says, oh, great, you're 15, even better, I think that's still entrapment because, again, this person still...
They brought it up.
Pardon me?
They brought it up.
Exactly.
They made the circumstance of the crime at issue.
Correct. The person was ready and willing to engage an adult. That's why they went on Skip the Games. Whether they later became ready and willing to commit a different crime when presented with that opportunity, I think, is a different question. And this is a quote from Jameson that...
Okay, I'm going to stop right there because did you get that? They said, even if the defendant had said, oh, yes, I'm fine with it, it's still entrapment because it's a police conduct that matters, not the defendant's conduct.
Well, you know,
it's because the police brought it up.
Here again, the average person who's trying to decide culpability here and sees a few chats that the police and the prosecution put out there, they miss all of this subtlety here because it's the objective case, the objective analysis here of entrapment. It's viewed very differently than if it were the subjective one. And that's why they're trying to cut through. I mean, this Mr. Doman's playing it a little bit cutesy by half in a way because he said, we don't even have to look at objective versus subjective. But when he's pinned down on a couple of things, he certainly goes to that. But still, it's important to look at, you know, you're depriving somebody of their liberty, right? So you should be taking every opportunity not to do that. Remember the presumption of innocence. So what did the policeman do? Did the policeman do anything that would make it appear? And just merely nodding or going grunting or whatever, as what Eddie said, is right totally on. And you know, people need to understand that when they look at these cases, they are not you know, cut and dry. You know, I don't know how many times we've all been called the P word, for example, right? And, you know, cases like this are hard. There's a legal standard, and then there's sort of the social contract of how we want to treat minors. And we're failing at both of them. Look at how they're struggling just to pin down what is entrapment, which if you asked people 5 things they knew about the law, I'll bet entrapment would be one of them they'd bring up. And I bet everybody thinks they know what entrapment really is.
Well, they're asking all the right questions, so this should be very helpful to our cause.
I think I cited in my brief, but maybe I should have emphasized it more, where the court said, discretionary investigative enforcement measures extend beyond a tolerable level when, by design, the government uses procedures which escalate criminal culpability. I mean, that's this case to a T. In every situation, and really, I guess what I mean to say is the entire construct of this sting operation was designed to take people intent to commit one crime and get them to commit another crime. Under Jameson, That's entrapment, plain and simple, for everyone, I think, involved in these sting operations.
Let me try and clarify. And I think you've maybe already said this or answered it, but if your position is that even in the circumstance I described where the decoy says I'm actually 15 and the defendant says no problem, that is still entrapment because of that. So in that circumstance, so is there never a circumstance on other than on an adult website or something that has been, billed that you have to be, or there are protections to say you're over 18 or whatever it is, that you cannot, it's entrapment on a website like that, short of, I think you answered earlier, evidence that actually we knew that this website actually wasn't just for adults. But when that's not the case and it's an admittedly, adult-only website, the police going on there and initiating sort of any kind of conversation is going to be entrapment.
And the reason she points out when she says what we said earlier, that apparently this website isn't just for adults, the what is his name? The defense attorney pointed out earlier that Genesee County does other sting operations where they are looking for minors on these websites, sex trafficked minors. And he said that is what, the focus should be on, finding those minors, not offering minors to men on this website. And remember, this is an escort website where people go on there looking to be paid for sexual services. And so it makes sense that there might be some minors who are being sex trafficked on this website, but they're not being offered as minors. I can tell you that much. That's very different from like what was done to you, Norm, which was it was not an escort website. And the majority of these sting operations are not conducted on these escort websites. They're conducted on regular hookup and dating websites. So that's what they're talking about.
Yeah, what Justice Kavanaugh is saying, like I said a minute ago, is they're trying to establish where are the guardrails, where are the parameters for these cases. That's it. Because you can kind of tell that, I think you can kind of tell, maybe I'm totally wrong, but they seem to be very willing to rule in Jade's favor, but they're trying to figure out where are the rules, where are the guardrails. Once they have that, then they can sit down and look at it. But that's very different than what happens. I point out again, I'm constrained to point out in the trial court where you really have to win these. That's where you really have to win these cases, because most of the time you don't get up there.
Right. And she points out as well that, they acknowledge that Jade or anybody on this escort website maybe they are engaging in some kind of illegal conduct already if they're seeking, a prostitute or prostitution services. However, police are introducing a different crime to them. Right. So they're acknowledging that. They're not saying, they're completely innocent. Maybe, they weren't, this guy was not looking for anything illegal. Now, on the website, like the one you were on, Norm, and the ones that the majority of these men are on, there was none of that. Those men were totally looking for legal conduct, nothing illegal. So when it's an escort service website, yes, we can acknowledge that, okay, yeah, maybe he was looking for paid sex and that's illegal, okay. But that's very different from seeking to buy a minor for sex, which is what these law enforcement officers and prosecutors are putting out there, that these men were seeking minors to buy for sex. And that's just not true.
In this bait and switch context, correct? I mean, if this were just a prostitution sting, we have no entrapment argument. Right. So in the context of the bait and switch procedure, yes, I think that's correct.
Sorry. I was just going to say, what if the defendant asked if she was under 15? Asked if she was 15. I like 15-year-olds. 14. What if they had done that on this adults-only website?
I think, again, that's talking a lot of, to me, that feels a lot like predisposition, right? And the question is, were police, was this police operation designed to only catch those ready and willing, not the circumstance of each individual defendant. And I think...
But isn't that more like the drug dealer offering drugs, just, hey, drugs for sale, anybody walking by? Isn't that?
Okay, I'm going to go back to the other question the other judge just asked. What if the defendant had asked the decoy, hey, are you 15? I say then, yes, that's totally probable cause right there, predisposition, because you're on an adult website and you're indicating, hey, I'm looking for a 15-year-old.
Yeah.
But why would somebody on an adult website ask somebody, hey, are you a minor? Are you 15? That's not common. And so I think what law enforcement and prosecutors have been trying to present the illusion or the image that, you know, men who use these websites just know that there are minors on here, right. and that the men who use these websites are supposed to, they know how to find these minors on here.
But what Mr. Doman does, though, you'll notice, is he draws the court back to the central questions at hand, which is, you know, he doesn't even tackle that because he doesn't want that to be part of their mind. Remember, it really isn't, because the issue is something quite different. That is a little bit more on the obvious side, and they're trying to put the guardrails on it, including when you know that, you know, at what point you know that and what you do beyond that. And the police bring that up.
But to help our cause, I think Mr. Doman should have said, yes, if the defendant had asked, are you 15? Then yes, that makes a difference. At that point, we can assume, it's logical to assume that this person was looking for a minor. But in this case, no, the defendant did not ask. It was police that brought up age. The defendant never asked about age because the defendant automatically assumed this was an adult, like the decoy had presented themselves to be to begin with. Right? So I think it's important for us to acknowledge that, yes, if they're asking, hey, are you 15? Are you a minor? Yes, it's fair to say that yes, that person would have been looking for a minor, but that's not what is happening in any of these cases.
Oh, yeah, I think you're making a good point of we should point out that we see that. We see the difference there. Yeah, I agree with you. Good.
Yeah, and yeah, exactly. We're not defending that. We're not going to sit here and say, oh, if somebody had asked if they were 15, then that's entrapment and they're innocent. No, of course we're not going to defend that. I 100% agree that that is probable cause to believe this person is seeking a minor. That's exactly how it should be done.
Yeah.
Yeah, and like the attorney is doing, he's trying to not go that direction because his case isn't like that.
Right, it's not like that, but I think it would have helped if he had just answered it and if he had just said yes. That changes the situation.
He did what he did. You know, he doesn't want them having a lot of this in their mind. He wants them to focus on that key element of the Jade case that will probably help his client most of all.
Right, but I think it would have helped if he would have just
care about.
I think it would have helped if he would have just said, yes, of course, that would be different. And that's something my client did not do. Now, this other judge jumps in and changes it. And that's why I stopped it right there, because I felt the need to point that out, because we get accused of defending pedos all the time. And I'm showing, no, we're not defending pedos. We're not defending anybody who has shown behavior that indicates they were looking for a minor. What we're defending is totally different from that. And yes,
well, that's a substitute for thinking. You know, it's easier to call us. You know, I was called that again, that word today, and you know, it's easier to just throw that out, you know, than do any actual thinking.
Of course.
A little more like they're coming in and they're the one initiating.
I don't know, because I think it was Justice Kavanaugh and Jameson or Gillette where he wrote that entrapment can occur even with someone who is ready and willing to commit the crime. And I think that's a strong point in why we need to be looking at the police activity rather than all these questions about the individual defendants, which starts to look a lot like predisposition.
I think one area where the court could help clean up the law here is on standard of review, and that's the first question we asked about. And I don't, maybe I missed it, but we really dug into that very much here. It seems to me that we could clean it up by saying, well, there's in these types of cases, there has to be legal findings and there have to be factual findings. And when it comes to factual findings, because the trial court is there reviewing the evidence and able to judge credibility and make determinations, that is reviewed for clear error, and then legal findings are reviewed de novo. Do you have any problem with that standard?
No, that's exactly the standard I'm advocating for.
What do we do with the trial court's finding that he did not believe defendant when defendant claimed that he did not believe the decoy was 15 years old? I mean, there's this exchange, got to be 16, no, I'm 15. The trial court concluded defendant believed this person to be 15. Isn't that reviewed for clear error?
Correct, Your Honor.
And then what do we do with that? I mean, how do we say, no, that's clear error here? When there's two instances where there's an actual, got to be 15 or got to be 16, and the response is, no, I'm 15.
So his point is, why is it that the court was able to rule that the defendant believed this person was 15 when actually there's clear evidence that he said he didn't believe they were 15. He said you have to be at least 16. That's proof that he didn't believe they were 15, even though 16 is still a minor for these purposes. It's still, and I think the law is they'll do that because it's like if it's below 16, then it's a more severe punishment or something. But that's a good point he makes. Like, why is that not an error there? Because they said, oh yeah, he definitely believed that this person was 15, and they charged them with soliciting a minor under the age of 16. Well, and even though there's proof that he did not believe they were 15, he said, so at the very least, no, he did not believe she was 15. He said 16. So if he was, at the very least, they should have charged them with 16 or over, right? Not under 16.
Yeah, I focus more on the first thing that he said, which is what I was, suggesting earlier. When we're dealing with the trial court, he says, how should we handle this? Because we weren't there and we don't know I would add context. I'm maybe superimposing my belief there, but he said maybe we ought to, we weren't there. So the trial court's job is to do a factual review, and we weren't there. So maybe what we ought to do is let the facts stick where they are and then deal with a de novo, a totally new review of the law, and which really opens that up, because that's not what is done in other cases. Okay, they can only look at a very narrow sliver of the law where the judge is clearly off his rocker. So that's mind-blowing that he even suggested they'd be willing to go there, right? And then
right.
And then you get down to that other stuff. Okay, so if that's the case, counsel, and you agree with me on that, what do we do with this 15 versus 16 thing? And one of the elements they may come down on is looking at the broad stroke of everything he did with the objective test. On the whole, what does it look like? And I think that's where he's going with that, Justice Dara.
I think the point is that even if he were guilty, he's charged with the wrong crime, because he's charged with soliciting somebody under the age of 16. And he clearly did not believe that this person was under 16.
Yeah.
He believed that they were at least 16. And that's the point he's making. So even if they were to say, oh no, this was not entrapment, he's guilty, the charge is still different. So that's what he's pointing out, that the court erred in ruling that the prosecution had proven beyond reasonable doubt that this man believed the decoy was 15. He did not. It's clear from the evidence that he did not believe the decoy was 15. He did not believe the decoy was under 16. Therefore, the charge is wrong. So that's the point of this.
So no, I don't think this court could call that clear. I disagree with that finding, but that doesn't mean it's clear error or that this court could find that it's clear error. I don't think this court needs to find clear error in that circumstance to decide in our favor, because again, I think really what the trial court was talking about was predisposition under a different guise. Okay. So I think we need to go back, look at police conduct, apply an objective test to this.
I don't think he understood
the legal
that.
Error that the trial court committed comes in.
Thank you.
Counsel, you brought up Jameson, which I agree has sort of some helpful language in understanding this concept. I want to just talk about sort of this escalating criminal activity. So we have a site here where maybe there's one crime and it's escalating to another crime. How would, in your view, how would that work if this exact same thing was happening on, I don't know, Tinder or, a dating site where it's just a normal dating site? Would that same analysis apply, sort of the Jameson analysis?
That's happening right now. Tinder, Grindr, all these sites, they've moved on from Skip the Games.
Right. So that's what I'm wondering, if that same analysis applies. We've got Skip the Games, or maybe, there's sort of one unlawful activity happening already. Mm-hmm. Those other sites, they are not.
And I think those sting out. I'm out of time, if I could answer
yes,
your
please,
question.
Yeah.
I think certainly there's an argument to be made that those types of operations are particularly reprehensible. But I think the same analysis applies. It's a question of, were police manufacturing crimes that the defendant otherwise would not have committed? And in those sting operations, the answer is yes. These are adult dating websites. The person went on seeking, an adult for companionship. And so, I think the exact same analysis applies.
I think what this judge is trying to understand is, because he's applying a certain case that says if a defendant was on track to commit a certain crime, but then police, intervene and suggested that the defendant commit a different crime, which on Skip the Games, it would be, okay, he was looking for a prostitute, which is illegal, but then police intervened and said, hey, do this with the minor instead. So they changed the crime and turned it into a more serious crime. So whatever case they're talking about applies to that. So I think she's asking, what about websites like Tinder and Grindr, where there is no crime? Nobody is on track to commit any crime because that's lawful behavior, right? And then police, that's different because there was no crime being committed, and then police show up and say, hey, how about you commit this crime? And so I think they're just trying to clarify the case you quoted, Mr. Defense Attorney, how does that apply to those? But to me, that shows, even more so, those men were not looking to commit any crime at all, period. So that's entrapment even more so.
I'd like to thank everybody that stuck with us for that. That is the defense side of this Michigan Supreme Court hearing. We are going to continue with a part 2 that will cover the state's part of this case. Please keep track of that.
And Norm is here with us today. You'll find that episode on his channel as well. And
please subscribe and like and share and make some comments for us, please.
Yes, we'd like to hear from you. And we do have some trolls, that are stalking us and, trying to discredit us and trying to silence us. And some of those comments, some of those misinformation comments do get reported to YouTube, and that's why they get removed. So we don't mind engaging in constructive comments, discussions. Those are welcome. But if you're here just to be ugly and to try to discredit us, and you're not even listening to what we're saying, don't waste your time, because we're not wasting our time on that stuff. Thank you for listening to Stinging Back, and don't forget, keep stinging back.